Good afternoon and welcome to Propelling New York Forward, a series of conversations about the biomed industry's response to the coronavirus pandemic and how we begin to restart the economy. I'm Wynn Thurlow, the Executive Director of MedTech, New York's association dedicated to growing the life sciences ecosphere. We connect the biomed industry through business development, education, and advocacy. For those of you who'd like to know more about MedTech and how you can connect with our members, please check us out at medtech.org. We see these conversations as integral to what we do here at MedTech, and we're able to make this series free to you thanks to the generosity of our sponsors, Regeneron Pharmaceuticals, MPR Associates, Thermo Fisher Scientific, GKG, Barclay Damon, and Fuse Hub. We'd love to have your company or organization join us as a sponsor so that we can continue to deliver high quality education to our diverse audience. I am pleased today to welcome Larry Gilroy, the CEO of GKG, and Tony Piazza, a partner at the law firm of Barclay Damon. Both GKG and Barclay Damon are partners for us here at MedTech in what we call Membership Advantage, a curated collection of service providers and vendors who we've selected because of their expertise, their ability to meet the needs of the biomed industry, and their presence across the state of New York. We are thrilled to have both GKG and Barclay Damon in our Membership Advantage. Many of you already know the good work that their firms do. But for those of you who'd like to learn some more, you can find out more about GKG at gkgrisk.com, and Barclay Damon is at barclaydamon.com. With that said, we have a very full agenda today, so I'm not going to occupy a lot of time. I'm going to turn it over in just a minute to Larry and Tony to talk about liability issues, risk issues, mitigation strategies that your company should and can be taking as you deal with the COVID situation and generally our changed work environment. After Larry and Tony's presentation, we'll turn back to the screen where you'll see our faces and we will entertain questions. If during the process of this presentation you have questions, you can find a Q&A box at the bottom of your screen. Just type in your question and we will get to as many of them as we can at the end of the presentation. With that being said, Larry, let me turn the mic over to you.
Great. Thank you, Wynn, and thanks to MedTech for inviting us today, and certainly my privilege to be co-presenting with Tony, who is one of the preeminent coverage attorneys in the country. As we go forward today, there are a lot of fluid issues around what's happening with insurance as it relates to this. And what we hope to leave you with is a current understanding of where those issues are, as well as some strategies that you may bring back to your business to help you as you move forward. So if I could, Joe's flicking slides for us. Joe, you could jump ahead. And get Joe to click. There you go. We do have a disclaimer. We'll skip past that one. And as we move into what our agenda is for the day today, we'll talk about the risk that you're facing as businesses in specific areas, both workers' comp and employee-related issues, general liability issues, things that are changing in New York State specifically. We'll also talk about what's happening in the area of business income losses and some final thoughts again for you as far as prevention and some other lines go. If you go ahead, Joe, what we're going to start talking about is employee actions. And the first area, Tony's going to dive a little deeper into the workers' comp. But from a workers' comp standpoint, as an employer, you're paying a premium for a 12-month period of time. As we've gone into this virus state, many businesses now have reduced payrolls. And one of the strategies you can take on as an employer is to touch base with your insurance carrier and reduce your premium mid-year just by reflecting those payroll changes. Many companies also have people that are either furloughed and idle but still on the payroll or have moved to home. And the Workers' Comp Board has come up with a new classification that may be lower than what you're currently paying. So again, consult with your carrier. It may be a place to save money right away or pick it up at audit. And as we'll talk about all lines of coverage, some by government mandate, but most just by goodwill, most insurance companies are willing to offer payment terms. So as you're looking at cost, if you're under cost pressure, both from a cash flow and a true cost standpoint, those are three areas to take a look at. One of the questions is, if somebody contracts the virus at work, am I going to be liable? And Tony's going to dig deep into that question, but ultimately, if it is considered a comp claim and you're carrying coverage, you'll be covered. We're not going to jump into HR issues in depth today, yet it is important to note, especially as businesses are looking to return to work and some employees are not eager about returning to work, that there are a lot of employment-related labor law issues that could be litigated. It's important that employers review their employment practices liability coverage if you carry. If you don't, it would be a good time to review it. And again, as you're bringing those folks back, working with your labor lawyer to make sure you're following best practices and that you have good documentation. With that, I'm going to turn the next slide over to Tony to jump into some of the more detail around workers' comp.
Thanks, Larry. And I'll just mention that Larry Gilroy is a broker's broker in New York. He's a go-to guy for me, and we work together on a number of different projects. So let's talk about workers' compensation for a little bit, and how, you know, we're looking at how COVID is going to basically affect different insurance issues for business owners throughout the state. So, you know, the New York workers' compensation law actually defines injury as accidental injury, but also disease or infection as may naturally and unavoidably result therefrom. That being said, exposure alone without contraction of the disease is likely not going to result in a compensable claim. And as you'll see through our presentation, the real watchword for these cases, whether it's workers' compensation or general liability, is what? It's causation. The claimant generally has the burden of proof that their disease, the virus that they picked up, the infection, was caused by something in a workplace or in a retail store or whatever. So we're going to have that burden of proof. Slide, please. So when it comes to occupational disease claims in New York, it's derived from you have to actually look at the nature of the employment and it results from generally recognized risk incident for a particular occupation. And as they say, history is your best teacher. Back in the 1970s, there was a tuberculosis epidemic. And there was this went through the Workers' Comp Board and then into the appellate courts in New York, this Nathan versus Presbyterian Hospital case. And the court affirmed the Workers' Comp Board's decision that a nurse contracted tuberculosis as a result of her exposure to a tubercular patient, concluded that the work exposure to which all nurses are subjected is sufficient to meet the essential needs of occupational disease. So as you can see, that makes sense. Medical professionals may have a stronger claim for occupational disease in asserting a workers' comp claim. But query, what about employees who are working for other quote unquote essential services, such as a supermarket clerk, a checkout clerk? We wouldn't have thought of that person being exposed on a daily basis to infectious disease, but here we are. Slide, please. So that being said, claimants may have some difficulty proving that exposure in the workplace actually caused COVID. And here's a couple of cases, workers' comp cases. The first one, claimant failed to establish, this is a holding, the claimant failed to establish that acute bronchitis resulted from an infection contracted while transporting a prisoner aboard a commercial flight. The physician conceded the infection could have been contracted anywhere. And what did we say a couple slides ago? Causation. So the claimant has to prove that this was caused, the infection was caused by something in the workplace. How is it proven? Generally, expert testimony. So we're going to see a lot of experts being retained in these cases. Similarly, this matter of squirrel case, claimant failed to establish the bacteria responsible for a staph infection was contracted on a business trip to England. The source of entry into the body was not established with any medical certainty. Next slide, please. Other potential workers' comp issues that we want to keep an eye on. How about mental stress claims without a diagnosis, without actually contracting the disease or the infection? One of the workers' comp cases in New York, a housekeeper at a nursing home was awarded benefits as the employee responsible for cleaning the isolation room of being subjected to stress greater than a normal work environment. That certainly seems relevant in this day and age. So we'd also have to look at the employer's compliance or failure to comply with government guidance regarding protective measures, and of course, work at home issues, which raises different types of risks. I'll turn it back to Larry.
Right. The good thing about what Tony's talking about in workers' comp is if it is deemed a workers' comp case, then you have coverage. But when you move outside of workers' comp, the question we receive often is, hey, I was thinking about this, could I be sued if? And unfortunately, the answer today is yes, you can be sued for anything. But let's jump into coverage. If you go to that next slide, please. So when we start talking about third-party liability premiums, I'll start where we were with workers' comp. Businesses today are often under severe revenue pressure and they're looking for expenses. So if your business has been impacted and you were not an essential business that stayed open full speed ahead, the exposure for your liability premium, it could be sales, it could be payroll, it could be visits if you're an attraction. Any of those things may be down. And if that's the case, again, you should be consulting with your insurance carrier to see if your premium could be reduced short term to help alleviate the pressure you're under, as well as looking at payment options. As we move into the third-party liability and best practices here in New York State, as you're allowed to reopen, you're really mandated by procedures from the state, and there are other best practices out there. If you're not following those best practices, it's not going to be good if you get sued. So attention to following those published best practices and good documentation around them is important. The other area we're keeping an eye on when it comes to liability is it sort of makes sense. Well, if somebody comes in and we're doing the right thing and they contract the virus, a third party visiting our business, I'd be covered, right? The answer is probably or maybe. There are exclusions to certain liability policies that Tony can jump into. That means you may not be covered under liability. So before you're opening, you should make sure that your liability policy will be providing that coverage. Next slide, please. So again, taking a look at where we're going with this, the types of claims that could happen. Fortunately, New York State, it hasn't been challenged in court yet, has put up some big immunity for healthcare facilities, hospitals, nursing homes, that type of thing. That may reduce exposure in that industry, but other businesses that reopen to the public, and the public doesn't just mean clients, it means the UPS person, it could be a cleaning crew, anybody else. What we're seeing is there's going to be a lot of targets as people contract disease. So again, good procedures, good documentation, and making sure you have coverage in place. Tony, let me turn it back over to you.
Thanks, Larry. Next slide, please. So, I thought we would just review the basic principles of what a plaintiff has to prove in a liability case, and let's kind of superimpose them on what we have here today with COVID. But normally the plaintiff's burden of proof, and this is New York, but this is pretty common around the country, 4 prongs: that there was a duty owed by the defendant, that there was a breach of the duty, proximate cause, and injury. Duty owed in New York is generally that a business owner needs to keep their premises reasonably safe. If there's a premises liability claim, they also have to demonstrate actual or constructive notice of the unsafe condition. Breach of duty in the COVID area, we're thinking it's probably failure to adopt or timely adopt measures to prevent the spread of the virus, such as installing glass shields at cash registers, requiring face masks, taking employee temperatures and things like that. Proximate cause, remember we talked earlier, this can be a tough issue for claimants. Difficult to prove due to the widespread of the virus and easy transmission of COVID-19. For instance, a defendant could say, well, yes, you have COVID, but you could have caught that at a family gathering. And of course, the last prong is injury. Next slide. So getting down to a case that, again, history your best teacher, 2001 case involving a cruise ship, class action lawsuit brought by passengers who sustained a foodborne illness during the cruise. The cruise line was granted summary judgment, meaning the case was dismissed. Why? Because the plaintiffs could not demonstrate that during the incubation period, the cruise line was the only potential source of illness. And I know we're all learning, frankly, too much about the 2-week quarantine periods and all that. And again, here we go with the need for expert proof. Defendant's evidence included an epidemiologist who discussed the incubation periods and potential sources of illness. Next slide, please. We're also looking at what product liability claims might arise, and I think this could pertain to the audience on this call. The products, diagnostic testing, experimental drugs, medical devices, health and hygiene products, PPE, the defendant's product manufacturers, suppliers, distributors, and issues, failure to warn, alleged breach of warranties, failure of the device to prevent transmission. Before I finish on this slide, two quick points. There may be governmental immunity, industry protections for some of these industries. The other thing is, remember we talked earlier about the 4 prongs of what a plaintiff has to prove generally in a products liability case. It's not so much breach of duty, but a defect in the product, a defect in design, that type of a thing. And that's also expert testimony. Next slide, please. Related issues on general liability claims. Plaintiff's comparative fault, for instance, ignoring social distancing rules. The other thing is that oftentimes defendants, which are sued, think, well, I was sued, but there might be some other potentially responsible party, so I think I'm going to bring them into the lawsuit, which is fine. But when we're dealing with a COVID type case, remember that causation issue could then be transferred to you, because now you have to demonstrate that it was caused, or the exposure was caused by another party, and that puts the burden on your shoulders. Next slide. So we're already starting to see some third-party suits, liability suits being brought against defendants across the country. Here's a couple of examples. An Illinois wrongful death action filed by a former Walmart employee, alleging the store wasn't properly cleaned and employees weren't provided appropriate protective equipment rather. How did they get around the workers' comp bar? They allege willful and wanton misconduct as an exception to the workers' compensation bar. Here's another one. Smithfield Foods, a large pork processor, was sued by some employees because they alleged that they were forced by their employer to work shoulder to shoulder during the pandemic. Several suits against cruise lines, there's no surprise. And then, of course, suits against nursing homes. Next slide, please. So with respect to liability insurance for COVID, as Larry mentioned, in the first instance, you would think that a business owner would say, well, if I get sued, I should have coverage. And when we look at a policy, we look at 3 parts. Insuring agreement, is the policy triggered? Exclusions, and then conditions such as notice. Well, insuring agreement, that should be satisfied. We've got an occurrence or an accident, we've got bodily injury, but how about exclusions? We're actually starting to review some policies for clients, and the first exclusion mentioned there, the first bullet, let's read that. No coverage for bodily injury resulting directly or indirectly from the transmission of a communicable disease by an insured or an employee of an insured. So that raises a really good issue. You need to take a look at your insurance policy, or have somebody take a look at it for you, because every policy is different and you never know what's in there, including this possible communicable disease exclusion. That one caused us all to kind of pause. Next slide, please. So we'll touch briefly on this. As I'm sure you've heard, there have been some legislation, some executive orders coming out of Albany. This first one grants, this is from Governor Cuomo, grants medical professionals immunity from civil liability arising out of COVID treatment. There's an exception if the conduct constitutes gross negligence. Makes sense, but knowing the plaintiff's bar, which is particularly aggressive in New York State, they might challenge the constitutionality of that. Next slide. The other thing that Albany did was, over the past 2 or 3 months, the courts have essentially been closed. they've been shut down. And because of that, statutes of limitations have been lapsing. So plaintiffs' attorneys, understandably, have been very concerned about their ability to file lawsuits in time. So the governor passed another order, which essentially froze the statute of limitations period. Interestingly enough, that order is lifting, I believe, today or tomorrow. So we expect some lawsuits to start getting filed in the next week or two. Next slide. And then the last, on the federal level, the U.S. Department of Health and Human Services issued an act providing immunity to individuals and entities arising from the manufacturing, distributing, administering, or using covered countermeasures, broadly defined to include drugs, diagnostic tests, or devices to treat, diagnose, cure, or prevent COVID. The only exception is for willful misconduct. So back to Larry.
Thanks, Tony. And next slide, please, Joe. So we've really covered on the liability issues, whether it's workers' compensation or general liability. I want to shift now to the topic of business interruption. And this was really the first insurance controversy that popped up with COVID, as many people discovered that there were exclusions in their policy relating to business interruption. So even though their business was shut down, there wasn't coverage. And there's a lot of unknowns still with this. The landscape is very fluid. There are federal solutions being discussed, both retroactively and looking forward. Tony's going to touch on some state solutions, and there are a number of lawsuits already being filed. So where this all flows out, we're not sure. Most of the exclusions around coverage on business interruption came forward after the SARS epidemic and were fairly intentional. So there's some strength to those exclusions, but it's being fought at a lot of different angles. Our recommendations to employers is to make sure that you understand if you can or should file a claim now, and you would be doing that to preserve your rights. Under most insurance policies, there's an obligation to report a claim on a timely basis. So putting a claim now can be a placeholder, if you will. Depending on what happens with federal or state solutions, there may also be some type of a federal program that provided a bailout, but in order to get that bailout, you might have to prove you didn't have insurance coverage. So there's a couple of reasons to go with this. It's by no means a slam dunk, yet we don't see any damage to do it. We've advised all of our clients to file. Employers are also really encouraged to make sure you're documenting those expenses. What are your lost revenues or increased extra expenses? Keeping good records of those could be very valuable, whether it turns out there's merit to your insurance claim, or if it's something with a federal or other type bailout or tax related issues. So tracking that carefully is important. Next slide, please. As we take a look at the claims that are out there, again, just hitting on that, look at revenue and looked at increased expenses, realizing that it is going to be an uphill battle, yet it's not one that we want to just throw in the towel on. Next slide. As we take a look at business interruption, we'd also encourage employers not to just think about direct losses to them, but contingent business interruption affects the supply chain. So maybe you have a client or a supplier who is not able to perform even though you were, but that indirect effect impacts your businesses just like you were shut down yourself. So we'd encourage you to take a look at those as we go forward. I'm sorry, could you go forward one there, Joe? Yeah, so that's the contingent and one more ahead of that. As we look at what insurers are doing when claims are being filed, many are citing portions of the policy that could trigger a denial of coverage. And one of the things that's important, I think Tony will touch on this, is when you submit that claim, the insurer owes you a duty of examining that claim. So in some areas, we're seeing claims denied almost the minute they come in. That in and of itself may open up some more opportunity for coverage as we go forward. Next slide. So again, taking a close look on your business interruption and examining those policies is something that we're encouraging you to do. And while I'm hitting on that kind of from a highlight, I'll flip it over and turn to the next slide to Tony to dig in a little deeper.
Thanks, Larry. So when we're looking at the business interruption coverage and also coverage for cleanup of contaminated premises, we look at the property portion of the policy, and I don't want to get into too much detail, but generally speaking, property policies are usually triggered by what? Direct physical loss or damage to the property. Next slide. So surprisingly, direct physical loss, although there are many definitions in insurance policies, in most that we've seen, direct physical loss is actually not defined. And if a term is not defined, as you probably know, if there's an ambiguity with respect to the application of a policy term to a factual situation, the ambiguity gets resolved in favor of the insured, the policyholder. So the question here is a property's exposure to coronavirus the equivalent of direct physical loss? What if there's no exposure? And there are certainly some lawsuits that are being filed like that, such as this case in Louisiana. Restaurant seeks business interruption coverage, argues that potential contamination of property by a virus is sufficient to trigger coverage. That certainly sounds like an uphill battle. Next slide. Here's another lawsuit which was filed out in Chicago, again for business interruption coverage, seeks coverage for losses. Restaurants and theaters seeking coverage for losses caused by shutdowns due to COVID, and alleges bad faith because of the insurer's failure to investigate the claims before denying coverage. And it's always good practice for an insurer to conduct some investigation before reaching a decision on their coverage position. Next slide. So the question then is contamination by a virus the equivalent of a direct physical loss? And there's actually a split in authority across the country. Here are some cases in which the courts in different jurisdictions have said, yes, it is direct physical loss. New Jersey, ammonia. New Jersey, asbestos. Colorado, gasoline vapors. Virginia, defective drywall. Massachusetts, an unpleasant odor. So these indicate that contamination can be direct physical loss. Next slide. But then there are other courts which have held that contamination is not direct physical loss. Michigan, mold. Ohio, mold. California, asbestos. So it seems to be a bit of an open question. But then we get to our next slide. A case in New York State. The Southern District of New York, which is a federal court, received a lawsuit by this insured Social Life magazine, and the insured asked for a preliminary injunction seeking business interruption coverage. Basically, a preliminary injunction is going to the court saying, Your Honor, we need relief now. We can't wait any longer because this is harming our business to a significant degree. And the court held, again, this is a very early stage, but the Southern District of New York looked at New York state law decided by the state courts and said, no direct physical loss. You haven't proven it, at least at this stage. And COVID does not constitute physical damage. Now, again, this is a federal court interpreting New York law, and it's a very preliminary case, but this could be a little tip-off as to where the New York courts might be going, at least on the direct physical loss issue. Next slide. And aside from the direct physical loss, remember we discussed policies have insuring agreements and exclusions. Here's an exclusion that's found in some policies, not necessarily all policies. A bacteria and the virus and bacteria exclusion. So even if there is coverage in the first instance, many policies contain this exclusion. And the exclusion was included in many policies as a result of the SARS outbreak in the 2000s. Let's go to the next slide and you can actually look at one of these exclusions. This is an ISO form, which means a pretty standard form in the industry. We will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. So if the policy has direct physical loss, but it also contains this exclusion, we know the direct physical loss path is probably going to be a dead end for the insured. However, question mark, here's a question that the court would look at. Does the exclusion apply if a virus didn't cause the loss, but if a government mandated shutdown caused the loss? That's another bit of an open question. Next slide. And again, one of the themes we're trying to bring out here is every policy can be different. You need to take a look at your policy or have somebody else look at the policy for you. Aside from the standard direct physical loss path, there can be other forms or endorsements in your policy which may indeed provide this coverage, such as endorsements relating to fungus, pollutant cleanup, communicable disease, civil authority shutdown, and contingent business interruption. These may possibly provide coverage. And an example is on the next slide. Here's a communicable disease endorsement we found in one of our clients' policies a couple of weeks ago. Let's read it for a second. We will pay, now this is a separate endorsement in the policy. We will pay actual business income loss sustained by you due to an order of the health authority that results in a partial or total suspension of your business operations at your covered location. So when I was a younger coverage attorney, I was taught read policies from back to front, and this was found at the back of the policy and add on. One more slide, please. There's also often policies contain civil authority shutdown endorsements, which may or may not apply. And here, of course, we've got civil authorities telling businesses to shut down. This is usually triggered only when a civil authority prohibits access to the premises, but these endorsements often relate to another building in the neighborhood of the insured premises being closed down, and you can't get into your own building because of the adjoining building, and that's often like a tornado loss. So we think this is probably going to be an uphill battle. And then next slide. Some states are looking at possible legislation to essentially force insurance companies to pay on business interruption claims. These have been brought up and examined, and they're pretty much tabled these days. There's no federal bill yet. And of course, the insurance industry has a lot at stake here. We had heard one statistic, which is that with respect to business interruption, the insurance industry collects about $7 billion a year in premiums. But if they had to pay out on these business interruption losses, it would be $300 billion per month. So trying to force the insurance industry to basically pay when they shouldn't have to pay under certain endorsements raises constitutional issues, which I'm sure the carriers would fight on. I'll turn it over back to Larry. I think you're muted, Larry.
Yep, there you go. Sorry. If you could go to the next slide. Thanks, Tony. As we're wrapping up here before any questions, a couple of other areas of concern. So cyber liability today is primarily around ransomware, although there's still a lot of malware that's out there. And the unfortunate issue is many of the largest corporations that were the initial big targets have gotten pretty good at protecting themselves. And so the cyber criminals, who are very much organized under approval of different foreign governments, are targeting businesses that are the size of many of us on this call today. And it's happening in our region. We've paid some very big Bitcoin type claims ranging up in the 6- and 7-figure numbers. So this is picking up, and with employees being remote, a lot of companies' security has slipped to a degree. So it's an area to really review your cybersecurity defenses and make sure they have adapted to the new normal that we're in. Cyber insurance coverage itself remains relatively inexpensive, and it's still not a coverage purchased by most businesses. So it's an area of opportunity if you haven't looked into that. Next slide, please. As we take a look, going back to who can be sued, you know, we can all be sued. Doesn't mean we'll be held negligent, but it does mean that we're going to be up for a battle at least. And so the more you're aware of best practices and that you can adopt them and document them, the easier it is going to be to provide a defense for you. Also important to remember that insurance carriers have a number of tools at their disposal that can help lower your cost if your business is slowed down and help you with cash flow. Today, we've really talked about liability and workers' comp coverage. This very much applies to health insurance as well. So your health insurance premiums, there are strategies there, both cash flow and cost, that can be looked into. Next slide. Tony has hit on, and again, I think it's critical to make sure your policies have been reviewed in detail. All those policies are different. And unfortunately, a lot of businesses are finding out today that the language in those policies really does matter. It's not all the same. Next slide. Investigation is critical here. So if you think something's going to happen, whether it's an employee-related injury or a third party, identifying and documenting what has happened as best you can, and getting in touch with your carrier right away is going to be critical to a sound defense. Next slide. So we'll stop there. Scary picture. I don't know where that one came from. But Wynn, again, thank you for allowing us the opportunity to present to your membership. And Tony and my contact information and slides will be available if people have questions. We're glad to take them now, as well as they can contact either of us here. So I'll turn it back to you, Wynn.
Fantastic. Thank you, Larry. Thank you, Tony. Joe, I'll let you turn us back on. There we go. And for those who are attending out there, just a quick reminder, if we got a few minutes for some questions. I've seen some, but to go ahead and use the Q&A box that you can find at the bottom of the screen. And as we do that, let me throw this question out to both of you, Larry and Tony. Many, if not nearly all, of MedTech members have been operating as essential businesses throughout the COVID pandemic. And one question that I know has arisen relatively frequently is, particularly now as we begin the reopening phase beyond essential businesses, we are finding ourselves with more and more guidance and recommendations about safety practices in the workspace. Do essential businesses face some increased liability for their safety practices or lack thereof that they used in the past that may now be superseded by additional guidance? In other words, we thought we were doing the best that we could under the circumstances. We relied on what we thought was good guidance. Now the state or someone else has come out and said, here are some additional steps that you need to take. What impact, if any, does that have on a business owner's liability?
It's a great question, Wynn. If I could take that, Larry. I mean, we talked earlier about what the plaintiff needs to prove in order to succeed against a business owner. And remember, we talked about breach of a duty. So what is the duty? The duty is to follow the standard of care. And the standard of care obviously has moved up a bit over the past few months because of the heightened risk. So it's one thing to rely upon industry experts, which is very good. But it's another to follow what the government has mandated, ordered, or recommended. And if a business does do that, then they can come back in a lawsuit and say, look, we did what we needed to do. We were in tune with what the guidance is from governmental experts and from experts that we've hired on our own. We followed those protocols, and that should really provide a lot of protection.
So I guess if I'm hearing you correctly, when both of you talk about documentation and kind of keeping a paper trail, I presume that would fall into that same category. Here's what we found out, and then, come this Thursday, we got new guidance, and so we responded in the following ways.
Right. I mean, I was taught when I was a young lawyer by my senior partner, who was an former FBI agent, and he taught me investigation wins cases. So it's all about, documenting things, putting it in your file, making sure you follow the protocols, and then, God forbid you do get sued, you can go back and say, here's our file demonstrating what we did.
Another question that's come in is about preserving your rights to make a claim. And one of the participants wrote in and said that he or she, I'm not sure which, had filed a business interruption claim early on. The carrier has already denied that claim. You talked a little bit earlier, I think both of you, about the kind of the evolving response, and that there may be a possibility that that which was denied in the past may become a reopened question. Does the insured have an obligation to refile a claim, or does the claim that was initially filed suffice for statute of limitations purposes?
Go ahead, Larry.
Well, and I think this is probably a two-part answer with Tony jumping in. So the insurance company would issue normally a denial. And one of the things we're looking at was, and there's been cases already filed in Illinois around this, where the denial came out almost instantly. And so the insured, the policyholder, in turn filed a suit saying, hey, you didn't follow your obligations to duly investigate this. So there's a question of, was it looked into, and did they cite, hey, you know, we've got this exclusion and here you go. And so that's either a denial or a reservation of rights letter from the carrier. What Tony and I have been looking at when these come back is there's probably a need, and it varies by circumstance in the policy, for one more letter back to the carrier saying, let's agree to disagree for the time being. This is a fluid issue, and I've set aside my rights. You've put this out there. I don't disagree. I don't agree with you, but let's see how things are going to unfold. So it's, you don't want to play ping pong with letters forever, but there's probably a need for a response to that, just to be belt and suspenders. Tony, I defer to you on this.
Yeah, no, I agree with what Larry just mentioned. What I also like to tell, if we happen to represent a company that's received a denial, is to go back to the carrier and say, will you keep an open mind if our client comes up with new information? And they always say yes. The other thing to keep in mind is there's a statute of limitations, okay? And it's usually in property policies, it's usually 1 to most likely 2 years. And it's measured from when, usually from, I'm a cautious practitioner, so it should be from the date of loss. So something to put in the diary. But no, but bottom line, when is once the letter goes out, the carrier's been put on notice. Sometimes the carriers push back and say, well, that wasn't an appropriate notice. And so then you can always provide more detail.
A question that's come in is, are MERS and SARS considered endemic? And at what point is the label of pandemic potentially temporarily limited in scope? It's my understanding that when a disease pathogen becomes endemic, there seems to be the suggestion that it becomes a chronic or evolving risk.
I mean, this is, Tony, I mean, from the perspective of, you know, what we've discussed, insurance coverage, I'm here to tell you, I don't think I've seen a policy which includes endemic, pandemic. They deal in terms like virus, bacteria, microorganisms, contamination. So it's all about what the policy says, because that's the contract between the policyholder and the carrier. So I don't think those terms are going to be, you know, going to be in insurance policies. On a liability standpoint or a workers' comp standpoint, that could be a little bit more interesting. But again, you have to take a look at the statute of the policy. Those terms are usually discussed in the scientific community or in the press, but not normally in our world.
Another attendee writes in, would the pools in Missouri be liable for not providing a safe environment for the pool party participants? I presume he's referring to those pictures that we saw of Lake of the Ozarks and some other recreational places in Missouri where it appeared that the pools and recreational facilities were just jam-packed with parties.
Larry, if I could take that, I mean, when we're talking about a premises liability case, okay, we're talking about, number one, did the defendant keep their premises in reasonably safe condition? Number two, remember we talked about notice. So if we're talking about a pool back in early January in Florida, that's one thing. But a pool in practically anything in any part of the United States starting in March or April, you're on notice. These property owners are on notice that they needed to keep their places safe, and they didn't do that. So that would definitely raise a problem for them.
You know, one of the other issues that certainly has been in the news recently, and certainly for those of us in upstate New York, certainly in central New York and the Mohawk Valley, is the recent situation at the greenhouse facility in, you know, straddling the Madison and Oneida County line. For those who may not be aware of that situation, it's a large greenhouse facility where they had a significant outbreak of COVID. One of the potentially complicating factors is that the employer took the position that it had exercised all reasonable social distancing and safe workplace practices, and that it was not responsible for the employees who were by and large migrant workers who came in and were brought in by a subcontractor and were housed in motels, sometimes 4 to a room, 2 to a bed. You know, help us if you can. I guess I'm not looking for the final determination, but you know, for our members who are operating large workspaces, how far does your obligation extend beyond the workplace, and what does that mean if you know, or perhaps should know, that you've got employees who may be more susceptible to disease than the average person, and maybe bringing that into your workspace?
Larry, do you want to touch on that one?
Yeah, and I think the circumstances there are still very much to be determined when I don't have any firsthand knowledge of what's going on. But, you know, one of the things that's happening with best practices today is employers are asking employees to certify before they come back that they haven't been exposed in or outside of the workplace within a period of time. So, you know, the challenge we have is I can show up with no temperature today, but that's a lagging indicator. The leading indicator happened 14 days ago or something. So I think employers under the current best practices are expected to put that burden of proof on employees. Now, does that mean the employer has to trace the employee's behavior? I don't think we're at that point yet. Where we're starting to get into some issues, and this gets into labor law, is, you know, what if somebody posts on Facebook that they were at that pool party in the Lake of the Ozarks and they show up at work? When does the employer have to know about those types of things is probably one of those gray areas that's going to get litigated. But I think, you know, from a legal standpoint, it's those kind of one-offs rather than an employer supposed to be following somebody 24/7 a day. Tony, I think this is probably more of a legal question than insurance.
I would agree with what Larry said. I mean, generally speaking, an employer can only control their own premises. So it seemed like it would be asking to stretch the duty of care to tell an employer, you know, you should have also watched out for the motel that your employees were sleeping at. That seems like a bit of a stretch to me, but that's just, you know, again, as Larry mentioned, I don't know the facts enough to comment on that.
And let me follow up, or let's see if we can finish up on perhaps I'll ask both of you to put on your historian's hats and also take a look into your crystal balls. How's that for a unfair two-part process? But one of our participants writes in and asks, you know, looking back at the Spanish flu, or perhaps other previous similar situations, did those activities, did the Spanish flu, did previous pandemics change in any significant way the state of the law and risk issues? And if so, do you gentlemen believe that COVID is going to result in significant changes to how we look at risk, or will this be a kind of blip on the radar and we'll return to normal at some point?
I'll let Larry go on this one. I mean,
Thanks, Tony.
Let me just say that, you know, I'm a student of the law. We read a lot of case law. I'm an insurance coverage attorney. I'm here to tell you, I can't think of a lot of cases that have been cited in the past 10 years that go back more than 40 or 50 years. So they're just, the law just was not developed that well in the early part of the 19th century. It's still being relied upon today. So looking back in time, what I'm seeing is that the Spanish flu was a blip. This seems like a lot bigger than a blip, and I'm guessing that things are going to change substantially because of it.
I'll go this way. When my aunt and my godmother was born about the time of the Spanish flu and is still kicking now, so she's probably the person we ought to bring in for that question. But you know, the SARS, not so much the Spanish flu, but SARS really resulted in the insurance industry putting some of these exclusions into policies. And the discussion today is a pandemic similar to something like terrorism? Is it a risk that can't be shared through traditional risk sharing that's insurance? And so there is a lot of dialogue going on in Washington now about, much like flood insurance and much like terrorism insurance, is there going to be a federally backed program of some sort that allows people to buy coverage for pandemics? And I think that's where a lot of the focus is going to be. We do a lot of work around disaster planning and understanding what clients' risks are. And I would say, you know, the number that have ever mentioned pandemic when they were talking about the big risks facing their businesses were few, if any. And, you know, going forward, I think people will be looking at this in a much different lens because, you know, just the nature of the disease sounds like it could be back or something similar. So I think you're going to see businesses much more aware of it. I will say that businesses that have done good disaster planning, even though they weren't talking pandemic, were much more nimble when it came to being ready for this than those that hadn't really gotten around to it. So I think the way businesses view the risk will change. And I also think that the way tied to governmental programs that the insurance industry responds, I don't think anybody wants to be around next time around and say there's no business income coverage, or at least that you didn't have the option to buy it, which wasn't here today.
Terrific. Well, gentlemen, thank you very much. We'll wrap up on that note. Want to remind people who are online today or are interested in finding this again, all episodes of Propelling New York Forward are available after we've aired them live for you to log on. You can find them at medtech.org. It will contain the deck and the material that you heard today. I'd also recommend to you, and certainly feel free to give us a call if we can help connect you to one of the professionals at GKG or Barclay Damon, two really premier organizations, not just in New York, but really across the Northeast, is providing top flight service in both the law and risk issues. And so I want to thank both Larry and Tony and your larger teams for the work that you do. This has been terrific. A quick reminder for those of you who are interested, next week's guest will be Matt Watson, who's the Senior Vice President at the Empire State Development Corporation, the arm of New York State government that has really been responsible for both guidance on responding to COVID and also helping the state and its businesses get back on foot. So for those of you who are interested in that, that should be a lively, informative discussion. For those of you who have registered for today's webinar, you are automatically registered for the first of our 10 episodes. When we get beyond 10, we'll send you another notice, but if you've already registered, you're on for next week. We look forward to seeing you then. Again, Larry, Tony, and on behalf of everybody at MedTech, thank you very much, and we'll sign off now.
Thank you.
Thanks, Wayne.